Mr. Chief Justice, and may it please the court. My name is Valentino Torres, and I will represent the respondent here today, the state of Olympus, and I will focus on the Sixth Amendment issues as it pertains to Bobby Bronner. Now, my co-counsel, Ashwanika Dadwani, will focus on the Fourth Amendment issue as it pertains to the state of Olympus. So, we see Judge D.R. Fair sentences Bobby Bronner to 30 years in an Olympus State Correctional Facility. Now, a jury returns a guilty verdict on the possession of child pornography. Now, the petitioner here today, Bobby Bronner, argues that the admission of this hearsay testimony by Andy Somerville is violating his Sixth Amendment rights, protected through the Confrontation Clause. Now, this court should find in favor of the respondent, the state of Olympus, for two reasons. First, because Andy Somerville's statement was non-testimonial, and second, because the state of Olympus has a great interest in protecting the physical and psychological well-being of victims of under the age of 10 who may have experienced physical or sexual assault related occurrences. So Judge Fair initially overruled Bobby Bronner's objection that there shouldn't be an introduction of Andy Somerville's statement because this statement violates the Sixth Amendment rights. So first, Andy Somerville's statement was non-testimonial, so we must look at the primary purpose test as we see in Ohio versus Clark. So the primary purpose test, there's a great question whether, in light of all the circumstances, the primary purpose of the conversation was to create an out-of-court substitute for trial testimony. Now, when we look in the present case of Bobby Bronner versus the state of Olympus, we see that there was no primary purpose to create an out-of-court substitute for trial testimony. And why do we see that? We see that because initially, Andy Somerville sought out Officer Rael. So in an investigative atmosphere, we would have Officer Rael initiate the scene and and he would know what had occurred to Andy Somerville, and he would thus go with questioning.
This is a really tough case. The only proof of possession of child pornography is this statement by Officer Rael. What if this court cannot conclude whether or not the statement is testimonial? What happens then?
Well, as counsel of the state of Olympus, we agree that the justice system is not perfect. So we can only look back onto the evidence that we have accumulated through this through this process. Now,
is this problem cured by the cross-examination of Officer Rael?
Can you repeat the question?
Is the question, this issue, my concern that I expressed to you, was that actually cured when defense counsel had the opportunity to cross-examine Officer Rael about his recordation of Andy's statement? Does that somehow cure concerns here?
Yes. Well, we see in Ohio versus Clark that, Maryland versus Craig, which was decided in 1990, that as long as we have expert testimony proving that there was a case-specific requisite necessity to implement this hearsay exception, then that is all we need. We do not need any proof that this statement was actually completely valid. However, we maintain that this statement by Andy Somerville is truthful. However, we have this expert
Counselor, how do we know it's truthful if we can't talk to Andy? Sometimes children speak in ways that are imprecise. Sometimes they speak in ways that are not accurate. Sometimes they're misunderstood by adults. How do we get at the truth here if we can't actually speak to the person who supposedly made the statement? In cases, are we just to accept third-party assertions as to what children say all the time?
Now, Your Honor, in the facts in Bobby Bronner versus the state of Olympus, we see that Andy Somerville has experience practicing with his sister when she was practicing for her mock trial competition. Now, Andy Somerville is aware that if he lies in a court of law, that this will haunt him for the rest of his life and that God will punish him for it. So we see that based on the facts, we are led to believe that the statement...
If he has that sort of understanding, Counselor, why is he not mature enough to testify at trial?
Yes. Now, we believe that this protecting his psychological well-being is sufficient enough to do away with the face-to-face confrontation between the defendant, Bobby Bronner, and this child victim. So we believe that this face-to-face confrontation would further...
So why would remote testimony not be adequate here?
Remote testimony, are you referring to, let's say, like a one-way closed circuit television?
Yes, Counselor.
We believe that based on the state of Olympus law, that it's barring anyone under the age of 10 years old.
Well, we're here to determine the constitutionality of that law, so why is that law constitutional? Why can we not have children under the age of 10 give remote testimony?
Yes, Your Honor. We need to give respect to the state's interest in protecting the physical and psychological well-being of child victims. So, as we are doing that, this is how the process of the state will follow through. This is how we will adhere to the law based on the state's interest.
But just to pick up on my colleague's point, haven't we known for these last 30 years then? You point us to Craig. Craig requires not just the state of Olympus identifying an important state interest, but also the judge in the trial putting forward a special procedure to evaluate the witness, to consider all of these. We don't have that here. We just have the state of Olympus saying no person under the age of 10 years old. Can we accept that? Do you want us to change Craig in that sense?
Well, I see a lot of parallel between this instant case and with the case of Ohio versus Clark. In Ohio versus Clark, we see distressed children, and we have teachers having a mandatory reporting obligation to address the situation and to pass the statements from the child victims to the courts and to counsel. So we see that we must look at this from a case-by-case basis, as we see in Maryland versus Craig, and based on the facts that we are presented here today, this is how we must go forward in this process.
Well, isn't the law here counter to that? If we need to go on a case-by-case basis, here we have a law that says anybody under the age of 10. So that's not a case-by-case basis.
Case-by-case basis meaning?
This is just a law that blanket covers everybody under the age of 10, so that would seem to run counter to a case-by-case basis.
That is correct, Your Honor. However, as I've stated, with respect to the state of Olympus's intentions to protect the psychological and physical well-being of children, of child victims that may be associated with experiencing physical or sexual assault, this is how we must maintain our stance today. Now, my second issue today is the state of Olympus has a great interest to protect the physical and psychological well-being of child victims. So it is irrelevant that they're questioning of Officer Rael and because I'm sorry. Yeah, so we see obvious emotional distress of Andy Somerville when he came to Officer Rael's office. So because of this, it appears that Andy Somerville had been crying the day prior. It appears that he was experiencing this emotional distress. So because of this interest in protecting Andy Somerville's welfare is sufficient enough to dispense with this face-to-face confrontation.
Counselor, but We know Andy's crying. We know he's having a rough time for the record. But was this truly an emergency? Was Officer Rael concerned about Andy's safety of other students in the school?
Well, in the facts of the case, we see that Officer Rael initially was concerned about Andy Somerville's demeanor, and because of this concern, we are led to believe that he had a great interest in protecting his psychological well-being, based on the facts here today. Now, for the foregoing reasons, I respectfully request that this court find in favor of the respondent, the state of Olympus, and affirm Judge Fair's overruling of Bobby Bronner's objection to the introduction of Andy Somerville's hearsay statement, and consequently hold that Bobby Bronner's Sixth Amendment rights were not violated. So thank you.
Thank you, counsel.